Good morning on this level 4 Monday. I hope you guys are all well and you've had a good weekend. My name is Maurice Crespi. I'm the managing partner of Schindler's Attorneys, co-founder of COBRA, together with Engaged and the IQ Business Group. I'm joined by a whole host of panelists today. We have Ian Fleming from Engaged Business Turnaround, Paul Michael Keichel, a partner of mine from Schindler's Attorneys, Peter Gordon of Engaged Business Turnaround, Tisha from the IQ Business Group, and I see we've just got Gary has just joined us. He's from the IQ Business Group. He's from Schindler's Attorneys. I should know that. Welcome, guys. Thanks for making it today. I will start off by pointing out that COBRA is not about a company going into business rescue. COBRA is about avoiding a business rescue in circumstances where you're financially distressed, you're obliged to put business rescue to the vote in terms of the Companies Act, and you decide not to. What you do is you say that you are, you've approached the COBRA team. COBRA will assist in negotiating payment terms, let's say with your landlord. We have qualified mediators who are prepared to do it on a pro bono basis. And the idea is to strike relationships with your creditors with a view to not having to go into business rescue because your commercial solvency is maintained. And the methodology that we employ is to try and get the entire supply chain within COBRA. So if you say that a creditor is being heavy-handed with you, you come into COBRA, we try to get the creditor in because chances are the creditor's getting heavy-handed because there's external pressure, let's say from the bank. And then if the COBRA team can then work with the bank and strike up a relationship then the downward pressure is not that great. And every business within a supply chain, or every company within a supply chain can avoid business rescue. Business rescue does only apply to companies and closed corporations, doesn't apply to business trusts or sole proprietorships or partnerships. But COBRA, we're quite prepared to assist businesses as small as spaza shops. The idea is that no one will not have the benefit of professional assistance. We have over 1,000 consultants who are there to assist. So understand that whilst we talk about business rescue today, that's only if it's necessary. It's only if a landlord or other creditor is being unreasonable. So I'm going to jump right into business rescue. I'm going to ask Peter to please give us just a general overview on business rescue. Peter?
Maurice, thank you, and good morning, everybody. Hopefully you had a good labor long weekend. Laboring in the garden, I was. Business rescue, it falls under Chapter 6 of the Companies Act. It was brought into force in 2011, so still fairly recent legislation for South Africa. But there's been a lot of activity, and of course, as we speak, that activity in business rescue is increasing. The most essential thing to know about business rescue is by choosing to go into business rescue, the company has absolute protection. It has a moratorium against any legal action against the company. And that's not only against the company from people that you owe money to, that's any legal action against the company. How does the company go into rescue? One of two ways. Either the directors take a board resolution. It requires a 50% plus one majority of directors to vote in favor. The resolution, together with, importantly, a sworn affidavit, is filed at companies, at SIPC, together with a SIPC form. We can still do this and have been doing it during the lockdown period. Once filed at SIPC by way of an email, the company is immediately in business rescue. What that does is it freezes all liabilities of the company with a secured, unsecured, preferent, whatever the nature of the liability is frozen, cannot be paid unless in terms of a business rescue plan. The one important thing with the director's resolution is that the directors have to, in the sworn affidavit, state that they firmly believe that the company can be rescued. Now, rescue involves either returning the company to a stable financial position. the assets to exceed the liabilities and that it can trade in the foreseeable future, or the practitioner is allowed to do what we call a controlled wind down of the assets of the business in rescue. Because what the practitioner is trying to do at any one time is beat the liquidation value, not a high bar to exceed. And if the practitioner believes that, then he can continue with the rescue. If at any time he believes that that's not the case, then he's obligated to put the company into liquidation. The attraction is the freezing of the creditors, obviously in addition to the moratorium against any legal action, because as soon as you freeze your creditors, you are immediately given an injection of liquidity into the business, because those that you would have paid in the next 30 to 60 days, you don't have to. Importantly, the practitioner must raise post-commencement finance. That's the funding of the rescue. First port of call is normally the shareholders of the business. If that's a dead end, we will then try the banks to see if they're prepared to extend. As Maurice was saying at the beginning, the important thing in this process is communication with all the creditors to let them know what we're trying to do to achieve a successful outcome. The business comes out of rescue when the practitioner believes that the rescue or the plan that is implemented is substantially complete. And substantial completion doesn't mean it has to be every T crossed and I dotted, but rather that by and large, 80, 90, 95% of the plan is completed, and he can hand it back to the directors stroke shareholders to complete the final minor issues remaining from the rescue. There's no time limit on how long a rescue should take. We've had some that have gone on for years, but essentially, and Ian, who's on the panel with me today, we both have a policy of trying to get a rescue completed as quickly as possible, because obviously the quicker you do these things, the better it is for everybody. Not always easy, because you often get opposing views and a challenge to the plan. The practitioner is responsible for putting the plan together. In order for a plan to be adopted, he has to put it to the vote of what we call the affected parties. That's generally the creditors, the staff, as they are creditors at any one time. Shareholders, if they've lent money into the company, they vote on the plan, that group of people. And in order to get a plan passed, you need 75% positive vote, importantly, of only those creditors who voted, either by person or proxy. If you weren't there, the act is very specific. You can't claim after the event that you didn't vote for the plan, and therefore you still have a claim against the company. Those people that vote, and if the vote carries, if the plan carries, then everybody, the entire company and all its affected parties is bound by the terms of the plan. The plan can include a compromise with creditors, i.e. what we colloquially call a haircut. In other words, you're offering the creditors a payment less than they're demanding, which is obviously also a positive thing to do in a company if you're trying to restore the solvency and liquidity of the company. Employees' rights are not affected at all, in so much as the terms and conditions still apply. They still have protection of the Labour Relations Act. If the practitioner, which is able to do, wishes to go through a Section 189 reduction in headcount, then he still has to follow the process. He can accelerate the process because obviously he doesn't have to spend a lot of time advising people why the company's not going to be able to pay them their salaries. It's clear the company's in rescue. Not all their salaries, but partly their salaries. Anybody who's put money into the company after it's gone into rescue, and as I said earlier, termed post-commencement finance, is immediately preferred over creditors who were in existence at the day of rescue. Equally, the practitioner can offer security up to anybody putting money in. If there's a security available, if there's a property or assets in the business that are unencumbered, he can use those to secure the facilities being put into the company post-rescue. That's a very beneficial thing to do for the individual funding the company. Obviously, you have to make it attractive for them because, for goodness sake, the company's in rescue, so anybody's going to be very nervous of putting money in. But on the basis that they can take security and are preferred even if they don't, is an attraction certainly for the banks to continue providing facilities. Maurice, potted history. Hopefully that covers everything you wanted.
It does. Thanks, Peter. I see Ian's dropped off, so I'm going to ask you, being the only engaged representative that's around at the moment. He did WhatsApp saying he'll be back, just restarting his computer. Peter, as an alternative to business rescue, we made mention of just doing it informally through COBRA. But there's another statutory alternative found in Section 155 of the Companies Act. I was wondering if you can also take us through that and contrast that to business rescue, please. Thanks.
Sure. 155 is, Ian and I spend a lot of our time, and Maurice covered it at the beginning, we don't, even though we're both business rescue practitioners, we do spend a lot of time on informal turnarounds. The obviously, and Section 155 is, whilst in the Act, doesn't give the company the absolute steel jacket of protection against legal action. So it is a process, a legal process, whereby you get all the liabilities, all the creditors of the company, and you get them to agree to an informal compromise. In other words, they're going to get paid less than they're claiming against the company. So it is challenging, but it's doable. Certainly would be challenging in a situation where you've got many creditors, all of sort of small or similar amount. A compromise is an ideal situation where you've got a handful of creditors and it's thereby a lot easier to negotiate with them. That's not to say you couldn't offer it in a company with a huge number of creditors, but if there's just a few of them, it's a lot easier to negotiate. In order to get the compromise through, you need slightly different process of voting, because it's voting by class of creditors. So your secured creditors would be in a class, your unsecured creditors would be in a class, etc. And in each class, you need 75% majority saying yes to the compromise. And then it's drafted in a formal agreement, made in order of court, and you exercise the informal structure thus. Maurice, I think that's it.
Yeah, that's great. Thanks for that. I just want to turn to the moratorium, because there are several take-homes that are quite important, and there's the question of the moratorium and agreements. Now, the moratorium comes into place, and that's in relation to legal claims against your business. Those are suspended. But what of contracts? What happens to a contract? So let's take a lease agreement as an example. The contract actually still remains in force until the business rescue practitioner sends a notice to the counterparty to the agreement, informing the counterparty that the lease has been suspended. That's very important, because if that does not happen, if the business rescue practitioner does not do that, then the lease can still be cancelled and an eviction would still be appropriate. So one of the take-homes is, if you're not going to be using COBRA, if you want to use a business rescue practitioner that you know of, please make sure that you have a list of all the counterparties to agreements that you've entered into with the contact details, so that the business rescue practitioner can contact those individuals. It's another reason to go into rescue, incidentally, is if there's a need to suspend contracts. What contracts that don't become suspended are employment contracts, and that's another take-home. Let's understand how employees work. Now, the law in relation to employees is quite simple. The law, the Labour Relations Act, applies to employees exactly as it did prior to business rescue. So the employees are still afforded all those rights that they enjoy. They are entitled to be consulted upon if there's going to be a unilateral variation to their employment terms. They are not to be treated procedurally unfairly, which means that you can't just rush a unilateral variation to an employment contract. So let me deal with that. Section 189 of the Labour Relations Act deals with dismissals based on operational requirements, i.e. retrenchments. But the section is also of application when it comes to varying employee contracts. So you'll have let's say you want to vary salary down down to 75% of what it used to be. You have to start consulting in accordance with Section 189, which means you have to start a retrenchment process. And as an alternative to retrenchment, you can offer a reduced salary, and at that point, the employee has the election to take it. If the employee doesn't take it, then you have to retrench the employee and pay severance, which is often a dilemma, because how does one pay severance? What business rescue practitioners do there, when the company cannot afford to pay the severance, they can either try and raise the money, or they can strike a deal with the employees that the severance pay is paid over time. So important take home, you cannot simply say to your employees, this is the way it is. You still need to consult, and the employees still have every right that they enjoyed prior to the business rescue. Peter, I made mention of financing, raising finance. Now, I know you dealt with it in your opening, but I think it's quite important if you could deal with post-commencement finance in greater detail, but in two contexts. Number one, the labor context, and secondly, more importantly, I think if you can deal with suretyships, because we've had a lot of questions in the past, and how to deal with suretyships. Where I make mention to labor, the reason I raise labor is because we've had quite a few companies want to raise money to pay their staff. So where there's no money and they feel that it's absolutely necessary that the staff get paid, but there's no money. So in that context, shareholders lend money to the company, and the company is in financial distress. Can you comment on that, Peter?
Maurice, yes. I mean, intriguingly, we had a meeting yesterday, Ian and I, with a company that is considering business rescue, and it was a highly contentious issue in this particular case. If you're going to lend money to the company and you are financially distressed, and just in square brackets, what I didn't cover in the beginning, what does financially distressed mean? It means that within the next 6 months, and this is in terms of Chapter 6 of the Companies Act, within the next 6 months, the directors do not believe that the company is going to either be able to settle all its liabilities as and when they fall due, or in that period, the liabilities of the company fairly valued are likely to exceed the assets of the company fairly valued. So if either of those are in place, the company is classed as financially distressed and goes into rescue. So if you're in that space and the directors are having these discussions, then what is quite critical, if one of the shareholders steps forward and says, look, I'm prepared to lend money, as Maurice says, to pay the staff or anybody else for that matter, do not do that without going into rescue. Because remember what I said, as soon as you get PCF or post-commencement finance into the company, it's immediately preferred. What does preferred mean? The practitioner has to pay those people before he can pay anybody that was caught up in the rescue, i.e. owed money at the date of rescue. So it's a critically important point. Put the money, get the company into rescue, and then fund the company, because you're immediately protected. And if the company's in rescue and the practitioner's on board, he or she has the authority to give you security as well. So you've got a property, it might even have a first mortgage in favor of the bank, normally the case. You have fully in your rights to take a second charge on that property or any other assets in the business to secure the repayment of your funding. So that's an important point in that scenario. Maurice, the second thing, and it's certainly one of the questions that Ian and I always ask when we first meet, certainly in the SMME space, where very often the shareholder stroke director owner of the business has been asked to sign a personal surety, normally in favor of the bank, but we've had some in favor of a major supplier. I've had them in favor of landlords. So the important thing with the surety doesn't go away. And remember, it's the company that's in protection, not the individual. So if a surety has been signed, the company and the lender wishes to go after the personal surety, they are obliged to do so. There might be wording in the surety agreement that says they have to go via the company first, and if they can't get the principal debt repaid, only then can they go after the surety or the guarantee. But the banks are wised up to that, and most suretyships nowadays almost make it a joint and several obligations, so the creditor can go after the company or the individual, whichever he or she believes is going to be the easiest to recover the debt. So it's an important point. The practical questions around this is there a way of satisfying that surety, although the business rescue practitioner, remember, is trying to save the business on behalf of the people that the business owes money to, i.e. the affected parties. So really is not obligated to deal with any personal sureties, but most times the shareholder stroke director is involved in the business, and the last thing you want is somebody that's helping you in your rescue, which the practitioner is able to do, i.e. use the directors to assist in the rescue and work in a collaborative manner. And if the person's distracted because they believe they're about to lose their family home, etc., then it's not to the benefit of the business. So we would normally try and settle those sureties in some way. Now, how does one do that? I mean, Maurice, you've given me an example in the past. You know, you've got a shareholder who's owed R1 million and there's a 10,000 claim that is guaranteed.
I've actually got, Peter, for today, I've actually put together on a PowerPoint. I thought, here you go. So let's test that one out. This is on the voting of a plan.
Now, let me just minimize. Okay, so here we have it. You've got a shareholder at R1 million, i.e. he's owed money of R1 million by the company. You've got creditors unsecured, concurrent creditors for 15,000. And then you've got directors, shareholders, employees who are 100,000. Now, first let's deal with the voting. Remember I said earlier, you need 75% to say yes to the plan of those that voted. And of that 75%, of those that voted, 50% have got to be independent. So in this example, you put it to the vote. You've got votes in this of 1.115 million. The 15,000 creditors are classed as independent. What is independent? It's a person that's got no relation to the company. So a shareholder obviously has a relationship. The employees are also independent for a vote. So they would be classed as independent on their voting rights because they don't have a lending or any control capacity over the company. So in this case, you would, if you knew that your shareholder was supportive and if you knew your creditors were supportive, what you would have to do is get the shareholder to withhold his vote or only vote for, in this case, 7,500. Because of the 22,500 that voted, you've got to have the 50% majority, or 30,000 would vote rather. So 15,000 has to be. It has to be. They have to be the independents. If you don't get the independent vote, if indeed they voted, and the important point, if you published a plan, which the practitioner is obliged to do, and 10 days thereafter he calls what we call a Section 151 meeting to vote on the plan. If those creditors fail to turn up, then obviously there are no independent creditors voting and the shareholder can vote the plan through. But the shareholder often has to restrict his vote. What I was talking about earlier is, you know, in a scenario like this, if that shareholder hadn't put the million in prior rescue, then obviously it's quite critical that he's done so after rescue. And if he's put the money in after rescue, he still has a vote in the plan. It's not only the creditors as at the date of rescue that are voting, it's any what we call PCF creditors as well. In the voting scenario, they don't have any different status beyond the independent and non-independent. And you know, even if they secure, they're just ordinary votes on the proposal of the plan. But they are preferred in the payment of any amounts that get paid out. They have to be paid first before those in existence at the rescue. Maurice, did that cover it?
It certainly did. Thanks so much, Peter. Whilst we're on the question of employees, I dealt with the law in and what one legally has to do. But I think it's important for the audience to understand what a business rescue practitioner does, or what you do outside of business rescue as COBRA. So as a business rescue practitioner, you come in, what happens? Now, you know your legal obligations, practically what do you do? On the question of variable expenses and the importance of that notion.
So Maurice, thank you very much for that. I'm sorry I left you for 15 minutes or so. On the subject of employees, let me first touch on the subject of variable costs. So what we've been saying to every business that we've engaged with right from the beginning, since 6-7 weeks ago, is that the world is going to experience a paradigm shift, and corporates are going to have to experience a paradigm shift, and the ones that are going to survive are the ones that change to a variable cost model. In other words, the ones that link their costs to their turnover as much as they possibly can. In other words, take the fixed costs. The notion of fixed costs has to be changed in the corporate mentality to variable costs. We need to start making landlord costs. We need to start making rentals variable, and we need to make staff costs as variable as possible. And those are the companies that get that right are the ones that are going to survive. From a employee's perspective, when we start the business rescue, we get appointed. Within 10 days, we get appointed as business rescue practitioners. Within 10 days, we need to hold a meeting with, firstly with the creditors, which we know as the Section 147 meeting, and secondly with the employees or the employees' representatives or the representative of the trade union, if that is the case. And that is called the Section 148 meeting. And at that meeting, we express to them whether we believe there's a reasonable prospect of rescuing that company. And at all times during the business rescue process, as Peter probably highlighted earlier, we need to keep asking ourselves whether there's a reasonable prospect of that company being rescued. Otherwise, we need to liquidate. At that meeting, we are not bound by law to do this, but we normally let employees or their representatives know if there are going to be Section 189 retrenchments. Not sure if Maurice has touched on it, but what we have been doing is engaging extensively with those employees as part of the engagement that is required under Section 189, as part of the consultation that is required to explore alternative solutions to retrenchment. And what we've been doing, especially in the hospitality and the restaurant industry, is suggesting, as part of exploring those alternatives, that the employees go into a substantially lower monthly cost. In other words, making the cost more variable. We reduce the cost now. As the company starts operating again and the turnover grows, we can increase their costs incrementally. We can either link their staff costs or their salaries directly to turnover, where we actually show them what the turnover is every month, and they earn a salary as a percentage of turnover. Or we can keep the turnover confidential and can incrementally increase their salaries month by month until hopefully it's at the level that it was before. So this is all part of the concept of making costs variable, making your entire business one variable object. Moving
and how have the employees been? I mean, in your experience,
they've been very, very open to it, and because they would much rather have something, they'd much rather be earning something every month than earning nothing.
Yeah, that's what we found. We found that as well.
Yeah, and they found, and the general feeling is that they would rather have a job after, whether it's 3 months or 6 months or 9 months that we back to normal. They would rather have that security of a job, even if it's at 50% of what they were earning before, just so they can put food on the table rather than having nothing.
On the question of putting food on the table, now what happens if an employee is in fact retrenched on operational requirements? There's certain relief funds. I have Dean, he's been able to join us, so I'm going to ask Dean if you could please take us through the latest. I know that the regulations and the developments have been a moving target, so it's always good to hear from you. Dean?
Great. Hi, Maurice, and hi to the audience. Yes, I think firstly, I just want to highlight part of the pro bono initiative of COBRA is that we've got a whole panel of experts working, putting together a massive database of information of all these relief packages. And the quickest and easiest way of having access to this is going to the cobra.org.za website. And if you scroll down to the bottom of that page, there's a link under Contact Us that says Help Portal and Knowledge Base. And it'll take you to all the, a very nice high-level summary of all the initiatives. At this stage, I think there's roughly about 40 or so that you can get information on. And if you go to that same website at the bottom, there's a little green button that says Request Assistance. And it's quite intuitive where you can start searching within that button and it'll take you directly to the article and directly to the requirements that you may need or information that you want of those relief schemes. Just as a general observation, what we've seen a lot of questions are coming in is regarding the TERS relief fund, as well as the COVID loan scheme relief fund. And I just wanted I usually touch on the TERS one, and just a couple of points there that if you go to the website, it's very well set out. But the very important thing that I think all business owners need to understand is that with access to all these relief funds, your corporate governance and internal policies have to be really up to date. To make use of these relief funds, you have to be SARS compliant, you have to be UIF compliant and registered prior to the COVID pandemic. You have to have certain times, you have to have tax clearance things. Those are the kinds of check boxes all of these funds are looking at the first port of call. So just as a word of warning to everyone trying to apply for these, that has to be in order. But just for an example, today I wanted to chat about this COVID loan scheme because it was quite recent. And this is where the Treasury and the South African Reserve Bank sort of made 200 billion rand available for loans, and they're going to facilitate this through the major banks. And the important part is just some of the requirements that they're looking at through this is that your bank account has to be in good standing. So there's no arrears at the 29th of Feb 2020. You must be registered with SARS. You have to have had a capacity to loan money prior to this. So, you can't apply for these types of loans if you yourself haven't gone to your bank for a loan. And you must be in financial distress as a result of the lockdown, either directly or indirectly. And each bank has their own sort of requirements. And the loan will be evaluated and subject to their own credit application and process. A very important point is just to note that a lot of these loans will require the owners of the business to sign personal surety. So it's not just a free-for-all. There are some terms and conditions to it. But if anyone would like more information, please, first point, go to our website at cobra.org.za. And if you don't come right, please send an email into info@cobra.org.za and we'll be able to assist fully on that.
Dean, have the funds been efficient? What's your experience been?
Yes, so it's actually quite interesting. In terms of the TERS one in particular, we've heard of if you have the right documentation, you have your corporate governance in place and everything sort of ticks those boxes. We've heard of people submitting on a Friday and getting paid on a Monday. So the turnaround has been amazing. But as I say, I think the way they're looking at it is saying, who's applied, what boxes do they tick, and then they deal with those first. Otherwise, you'll get your rejection letters, they'll ask you for further documentation, and you can try then apply, but again, it won't be nearly as efficient as it could be if you have everything in order before you start.
Quite incredible for government to put that together as they
Absolutely.
did. Absolutely. Yeah, thanks for that, Dean. To the audience, we're just over halfway through the presentation. This is a webinar. The idea behind webinars is that we deal with questions. So you've heard quite a bit thus far. I'm sure you've got questions that are floating around in your mind. You can ask those questions anonymously, but please bear in mind that we could quite easily record this and just play it back every day. It would be far, far easier. The idea behind the webinar is that we deal with questions that are industry specific, or company specific. So if you have a particular question that relates to your company, ask it. Or if you feel that it's too specific, set up a Zoom consultation with us. We can have whatever professionals you require at that consultation. Bear in mind that the consultation's pro bono. Thanks. Okay, just moving on to, you were dealing with the question of staff. I want to ask you, Ian, first of all, the business rescue practitioner, if you can just deal with the skills of the business rescue practitioner, but also, the question of directors. Now, the law and how they cooperate, and also the question of what if the directors reveal to you that there's been some malfeasance, let's say they haven't paid SARS as they ought to have. Yeah?
Sure, Maurice, thank you. Let's first go to the skills of the business rescue practitioner. Now, the skills that are required to do business rescue and turnaround properly are very vast. It's a very vast skill set. We normally, so it's almost impossible for one person to have all these skills. So you'll find your best business rescue and turnaround outfits have at their core several senior individuals who, between them, possess the skills that are required to do it properly. Leadership skills are certainly required. Remember, you're taking over the board. Entrepreneurial skills are required. Ability to maneuver and to think and to strategize oneself and one's business out of difficult situations. Strategy, as I've just mentioned. Financial skills are critical in order to really the financial statements of the business need to be able to tell one a story. And then operational skills are critical. You need your guys on the ground who understand the business that you're in, who understand the core of retail, understand manufacturing, who understand all the various businesses that we go to, how they operate at a core. They don't have to be specialists in those fields, but they need to understand the intricacies of the business. Legal skills are absolutely critical. A lot of business rescue practitioners are attorneys because business rescue is governed by Chapter 6 of the Companies Act. It's having those legal skills and being able to understand all the case law that's taken place and all the legal precedent that's been set since 2011, since business rescue started, is also critical. Therefore, the legal skills are essential. And then the other two skills are deal structuring. We get involved in fairly complicated business rescues from time to time, where it's important to be able to understand capital structures and corporate finance and that sort of thing, and to be able to structure deals that make sense for the company. So deal structuring is another skill. And capital raising. We need to be able to raise capital both before business rescue and during business rescue in the form of post-commencement finance.
Yeah, and I just to jump in there, I mean, the fact of the matter is we have all these partners. I mean, what's happened is COBRA has become a marketplace in essence. We have partners who can provide the PCF finance, who can consult on the deal making. I mean, we have IQ Business. They've been around for over 20 years, and this is their specialty. So very, very important. I'm actually going to move on to Peter to deal with the question of SARS and malfeasance by directors. Peter?
Maurice, I'm happy to cover that. Can I just add a few things to what Ian was saying on the skills? Obviously, those are the hard skills. Please do confirm, and I mean, it sounds a trite thing to say, but if your business rescue practitioner walks into the first meeting with the directors with a massive ego, you know you're going to have problems, and we've experienced this. They are sort of people that aren't able to negotiate. You've got to have unbelievable negotiation, mediation, communication skills, and be flexible. So that on the softer level, just make sure that you're dealing with somebody that has those abilities, because you'll land up with a successful rescue. Maurice, malfeasance. If, as I have unfortunately experienced in the past, cases where the directors have been perpetrating fraud and the company's in rescue, The business rescue practitioner has slightly less authority to, well, he can't summons anybody, whereas the insolvency practitioner in a liquidation can, through a commissioner, summons people to what they call a 417 inquiry, which is a sort of mini court case, if you like, on getting to the facts. But the practitioner is more, because remember what he's trying to do is save the business. It's not necessarily trying to bring people down who have done something wrong. So what the practitioner is obligated to do is examine the business. He doesn't have to do a forensic audit unless he believes it's necessary, but examine the transactions that have gone through the business. If he finds anything that has been untoward, and it's in two different categories, if it's not an illegal act, it's merely failing to comply with the law in some way or another, SARS would fall into this category. So there's been under declaration of liabilities in the past, is obligated to advise, and the Act says the relevant authorities. It's not clear on who those should be, but clearly if it's SARS, one would say that you have to approach SARS themselves. Now, what Ian and I found is that, and Ian often makes this point, SARS are not there to bring a company to its knees and put it into liquidation. Remember, SARS does have a community mandate, and one of those things is not to bring about yet further unemployment in this country. So generally, they will work with the practitioner on full declaration, and then there's going to be obviously interest and penalties to pay. But as I think Ian was saying on the trays necessary for a practitioner, that's when the negotiation starts. And firstly, what we found is if you're open with SARS and are prepared to negotiate with them, they are relatively flexible. And then the other second point is, remember what I said at the beginning, is there's likely to be a compromise in the business rescue. And that compromise might be that we're going to pay 50 cents in the rand. And then SARS are impacted by that as well. So what you end up paying to SARS is very often similar to, or in some cases less than you would have paid had you declared the revenue in the first place. That's the limit of the practitioners. In other words, resolve the issue and find an equitable solution. If it's an illegal act, now this is fraud, what they in the Insolvency Act is termed as voidable preference. If there's any transaction of that nature, then the practitioner does need to report it, is obligated to report it to either the police, the NPA, or if it is a company that's regulated by a regulator, such as financial services providers are regulated by the FIRES Act through the FSCA, then it's the practitioner is obligated to report it to that body as well. Those entities are then obligated to take it forward. I have certainly dealt with one pre-Chapter 6, where a lot of the shareholders came to me and said, surely I was going to pursue the directors who had perpetrated the fraud to put them in prison. And that's not the point of turnaround and rescue. The point is to try and save the business, to pay everybody that's owed money, firstly. And secondly, the practitioner is not there to perform the state's duties, which is to enforce criminal activity. I think that's it, Maurice.
Yeah, thanks, Peter. I'm going to move on to the plan. I'm going to ask Ian to deal with the structure of the plan and how it works. But let me just give you an example of a business rescue that I was involved in, to give you an idea of how simple the business rescue was. Now, firstly, this is a business rescue that took place about 2 years ago. And there was the stigma associated with business rescue that we had to overcome, and we had to deal with that. Now, please bear in mind, importantly, there's no stigma in relation to where you find yourself now. It's an act of God that's beyond your control. So what happened is it involved a restaurant in Camps Bay. The restaurant just could not keep its head above water simply because the rental was too high. So what we did is we put the business into business rescue because the landlord was knocking on its tenant's door. And we got the business rescue practitioner, who's actually a partner of COBRA, to negotiate with the landlord. And prior to that, there was a meeting with the staff. The business rescue practitioner explained what he intended to do. He had that meeting, he went to the landlord agreed, and was pulled out of business rescue. It happened in the space of a month. It was really, really quick. And that's really the spirit, and that's the intention of a business rescue. If you can go into detail, Ian. Ian, you're on mute.
Thank you. A business rescue plan basically covers everything that a business plan would cover, that one would take to a bank. In addition to that, classes of creditors, for example, unsecured creditors, secured creditors who by name, by value, independent creditors, in other words, creditors who have nothing to do with the company, and then creditors who are not independent, such as directors' loans or shareholders' loans. Lists of assets, for example. And then what is the turnaround plan? The plan, the business rescue plan, has to spell out specifically what the plan is, what the operational plan is that the business rescue practitioner is going to implement and how he's going to implement it. We all know that plans very seldom pan out as they were put in direct accordance to how they were put on paper. People tend to understand that, and that when it comes down to putting the 3-year financial forecast in place as well, the business rescue practitioner basically has to formulate those 3-year financial forecasts based on his opinion of the company at that time, his understanding of that company, which he has gleaned very often in only 25 days since being appointed as the business rescue practitioner. So it's a very short amount of time, and the timeframes are very urgent, as Peter would have explained earlier, and they're urgent for good reason. But bear in mind that makes it difficult for the business rescue practitioner to accurately forecast how the plan is going to play itself out. What's a very important part of any business rescue plan is that the calculation of the liquidation dividend, were the company to be liquidated at that time instead of having been placed into business rescue. And then we need to compare in the business rescue plan what creditors will get under business rescue as a dividend, in other words, how much money they will get out of it, versus what they would get in a liquidation scenario. Now, a liquidation scenario is not a very high benchmark because, as most people know, under a liquidation, assets are normally sold at a fairly low price under a forced sale environment. So the amount that the assets get sold for then gets translated ultimately into what the creditors get at the end of the day. So we have to prove that in business rescue we'll get a better return than in a liquidation scenario. And normally we need to show a substantially better return. There's no point in showing that under a liquidation scenario, creditors will get 15 cents in rand, and in a business rescue scenario, creditors will get 17 cents in rand. Then you might as well liquidate it. So normally in our plans, we show quite a substantially better return for creditors than in liquidation. And normally our business rescues do achieve a substantially higher return for creditors than in liquidation. And remember, at all times during the business rescue, we need to consider, we need to ask ourselves, is there a reasonable prospect of saving this company? In other words, is there a reasonable prospect of giving creditors a better return than they would get in a liquidation scenario? And if at any time we cease to believe that they'll get a better return than in liquidation, then it's our responsibility to place that company in liquidation. But we've had very few instances like that. It is 99% of the time, in our experience, possible for us to get a better return, at least for creditors, than in liquidation. That is if we cannot return the company to a solvent going concern.
Yeah, I'm going to ask Peter to deal with that. What if the plan fails? Peter, if you can use SAA as an example and give us some insight into what happened there. Peter?
Maurice, yeah, look, there's a number of ways that failure depends on the definition of failure. You might fail to get the plan passed in the Section 151 meeting, so you didn't garner the 75% majority that's required, voting yes. In that case, the practitioner can suggest that he's going to revise the plan. He can take soundings from the assembled gathering. He can ask for amendments to the plan, and if he thinks they're appropriate, he can put an amendment forward for vote. That only needs a 50% plus one vote. And then the panel beat the plan in the meeting, as it were, and publish an amended plan. If it's not possible to amend, he can suggest to the gathering that he's going to try harder, and he's under time conditions to then propose a new plan. If the practitioner is silent at that time, then any of the affected parties can come forward with a proposal. And remember, any new potential, and you often get this if somebody's quite keen on buying a business out of rescue, they might buy up some of the affected parties' claims and thereby have a vote in the process, and then present an amended, a new plan to the practitioner. He or she does have to decide whether it's an acceptable plan, and if so, put it to the vote, and if it carries, then that is the new plan. If none of those happen, then the practitioner has failed to get a plan approved, and whilst they act silent on it, he then has to, however, take the business out of rescue and obviously by default put it into liquidation. So that would be the one failed plan. The other failure is if it doesn't work. Now, what does doesn't work mean? If these minor amendments to the plan, so we said we're going to sell this property and then we decide not to sell it and keep it because we get a better return if we keep it in the business, you don't necessarily have to go back to the creditors each time for approval to minor amendments. If it's a major amendment, it's not clear on the Act how this should be dealt with, but certainly Ian and I have the view that involve everybody all along the way. And then for a major amendment, we would go back to the creditors and ask for their approval with the amendment. Very often what happens, remember when you're doing a plan, as Ian said, the most important document in it is a 3-year forward cash flow forecast. Now, anybody that's been running a business under normal conditions will know the cash flow forecasts are generally wrong on the second day of their creation. So believe me, 3 years is definitely going to be incorrect. But on the basis of that 3-year forecast, the practitioners come up with his idea of how much he's going to be able to pay creditors in a compromise. And if he's said, we're going to pay you 50 cents in the rand and you end up paying 45 cents in the rand, it's adequate just to advise the creditors, which you're obligated to do on a monthly basis, keep the creditors informed, and give them a reason why you're reducing it down to 45 cents and continue with the plan. If, however, the business really is on its way out, the practitioner is then obligated to put the business into liquidation. And as Ian said, if at any point along that road, bearing in mind each month where the practitioner reports to the creditors, he's got to firmly state that he believes that this rescue will still result in a better return to creditors than in liquidation. And if that assumption is ever challenged, then it's liquidation. Or if the business really has just got to the end of its tether and it cannot be rescued, the practitioner is obligated then to put it into liquidation. It's a tricky one for practitioners because you can't not do anything. The practitioner can resign. The Act is not very clear on how a practitioner resigns, but we do have legal opinion that says at any one time the practitioner is able to resign. But to be honest, if you've been handed a task to resolving a problem, to merely resign because it got a bit tricky is not acceptable in my personal view, and I know Ian agrees with that. We would see it to its end, and if that means putting the company into liquidation, the practitioner then has to apply to court for a liquidation application.
Great, thanks. Thanks for that, Peter. Peter, well, Ian, before I get to you around the costs of business rescue, I want to mention to the audience that a big issue that we've encountered is the attitude that's apparently being adopted by certain insurance companies. So what COBRA has lawyers as part of it. I'm an attorney, I'm a litigation attorney. Schindler's Attorneys has a pro bono department. And if subject to the means test, there's a means test which I'll explain later, but if you fall within the means test, in other words, you've got no money to sue, to pay attorneys. What Schindler's will do is Schindler's will recover the amount if it believes that there are good prospects of success on your behalf on a pro bono basis or a contingency basis, depending on the circumstances. So bear that in mind. Have a look at your policy. If you want us to look at your policy just to give you a high level opinion, we can do that. Or as I said, we can set up a Zoom consultation. We'd ask you then to send us your policy first. Schindler's has a dedicated insurance department. They give webinars themselves on these policies, and just look out for that. You'll see it on the COBRA website or on the Schindler's website. Over to you, Ian. Costs of business rescue. Before you get there, I must mention that the liquidation that Peter was mentioning, that the obligation on the business rescue practitioner to put the company into business rescue is also a pro bono service. That costs between 30 to 50,000 rands to do so, and it's normally the shareholders who have to fork that money out. Not to worry, COBRA will make sure that that happens without the need to pay a cent. Ian?
Thank you, Maurice. The fees that can be charged by business rescue practitioners are set out in Chapter 6 of the Companies Act. Please bear in mind that the Act was written in 2008, so most business rescue practitioners do consider these fees to be outdated. We also consider these fees to be outdated, in other words, too low. However, we've taken the stance, as Maurice correctly pointed out, that business rescue, our professional fees will never get in the way of a successful business rescue. They will never stand between a successful business rescue and a liquidation. So, whereas the fees range in the Companies Act from 1,250 Rand per hour, including that for a small company, up to 2,500 Rand per hour for a larger company, including that. So we consider those fees to be a little bit outdated. So we normally charge approximately 3,000 Rand an hour on larger matters. However, when those are the fees that we put out to our clients. However, those fees are negotiable. Okay, so it's very important for clients to remember when we do quote them that they need to come up, they need to come back to us, and they need to say to us, we can only afford X amount of fees, or X amount of fees, or X amount of your time. And we always say to them, okay, that's fine. We will work within those parameters, and we will make sure that the job gets done. So yes, we will never, and it's a very, very important COBRA principle. And from where the pro bono, all the partners in COBRA are giving a lot of their own time, big investment in time in the pro bono aspect of it. And that pro bono aspect is the fact that fees will be waived to the extent that they will ever get in the way of a successful business rescue.
Yeah, no, it's often the fees that do get in the way, and it's often the fees that lead to liquidation. So the means test is set out on the COBRA website. It's www.cobra.org.za. You'll see how it works. It's pretty simple. If your business can't afford it, well, then you don't pay. That's effectively the crux of it, but have a look at the detail there. Yeah, so just to wrap up, thanks to the panelists, thanks to the partners who are prepared to support you in any which way they can. Please reach out to us. We haven't had any questions today, but doesn't mean you can't send us a question. Send us an email on info@cobra.org.za, and it will be addressed. We've got a ticketing system that goes into the mix, and it gets assigned to a team who will look after your particular matter. And you know, the importance of the pro bono is that it doesn't matter how big you are. In fact, the majority of companies that we're assisting are the smaller ones. We recently had a construction company approach us to deal with hundreds of their suppliers on a pro bono basis to actually assist their suppliers because they recognized the importance of the relationship that they enjoyed. So thank you, everyone. Thanks to the panelists. We are going to have another one tomorrow, and we have targeted webinars. Look out at the website for targeted webinars dealing with specific industries. Thanks, guys. Cheers.
Thank you.
Thanks very much. Cheers.